right, I'd like to welcome everyone this afternoon to our latest installment of our webinar series that we've been running here at the Dale Law Firm. Today we're going to be talking a little bit about administering a court-supervised special needs trust. The Dale Law Firm serves as counsel for a number of trustees, both professionals and family member trustees of court-monitored special needs trusts. And we felt that it would be helpful to have this webinar because we get asked lots of questions about this topic. And so hopefully everyone will find it helpful and interesting, and we'll be able to all work more closely and efficiently with the courts. That's the goal. So let's go ahead and get started. Administering a court-supervised special needs trust can present a formidable challenge to unprepared trustees. And in particular for family member trustees who aren't used to administering trusts, it can often be quite daunting to have to both grapple with administering a trust generally, but then also dealing with the various requirements of the court supervision. So hopefully today we'll be able to help you better understand what those responsibilities are. A trustee needs to understand and be mindful of the expectations of both the government agencies and the court when administering a court-supervised special needs trust. Obviously here you're trying to meet the requirements of really two sets of rules. You've got the government agencies that are running the benefit programs that the trust is designed to protect eligibility for, but then you also have the expectations of the court when monitoring a court-supervised trust. And these expectations are not necessarily always consistent. The benefit agencies are looking at different things than the court and vice versa, and sometimes they can actually pose some inconsistencies. Now, the government benefit agencies obviously are going to be concerned primarily with making sure that the trust is being administered in a way that complies with their rules. They want to make sure that the activities of the trust are not creating a problem for the benefit recipient, not making them ineligible, not causing them to receive income, things of that nature. We're really just looking at maintaining eligibility for those benefit programs. And of course, the trustee always has to be mindful of that. The court, on the other hand, is primarily going to be concerned with protecting the financial interests of the trust beneficiary. Now, obviously, continuing eligibility for benefits is part of that, but they're also going to be looking much more broadly at how the trust is being administered by the trustee, whether it's being administered in the best interests of both the trust and the beneficiary for long-term financial performance and so forth. So, as you can probably see, there could be some inconsistencies there with the priorities of those two entities that you're trying to satisfy. Just a little background on special needs trusts, because again, sometimes when we're working with family members, they're not as always familiar with the purpose of the trust. And a special needs trust, in essence, is just intended to receive the assets or property belonging to a benefit recipient, so that it can be managed in a way that allows that benefit recipient to remain eligible for government needs-based assistance. And these are programs like SSI, Medi-Cal, in-home support services, and there's a few others, but those are the primary needs-based benefit programs that the Special Needs Trust is designed to protect eligibility for. Trust distributions from a special needs trust generally are meant to supplement the basic support that an individual is receiving from their government assistance programs. And the trustee needs to work with the beneficiary and the representative payee to coordinate how the trust is going to work with the other assets that are available to the beneficiary, and then to use the trust in such a way that we're not running afoul of those benefit rules. It's really important for trustees at the outset of administering a special needs trust to make sure that there's clear expectations that are set for the beneficiary and or the beneficiary's family. Many times beneficiaries are not used to living with any sort of wealth. These are individuals who are generally on needs-based benefit programs, and suddenly there can oftentimes be large amounts of money that they feel are available to them. And so setting expectations so that it's clear to everyone involved how the management of the trust is going to run, how the funds and assets of the trust are going to be able to be used to support the beneficiary is important. And it really, by setting those expectations early, it really sets up a much better and smoother relationship between the trustee, the beneficiary, and, as I said, oftentimes family as well. And one thing you always have to keep in mind is that we're balancing support versus quality of life when we're thinking about these distributions. Again, the benefit agencies are really considering the government assistance programs as being the funds and the resources available to provide for the individual's basic support. And they really expect the Special Needs Trust to be supplemental and often just providing those extra quality of life sorts of distributions that, otherwise the person wouldn't have available to them. That's not necessarily how it has to go, but that's kind of the initial perception quite often by the government agencies. There's also another issue here that comes up, which is oftentimes we're working with children beneficiaries, minor children that have received funds, usually through some sort of litigation settlement or maybe an unintended inheritance of some kind. There's also this tension within the court that the court is expecting the family of the child to continue to provide for that child's support. Parents in California have an ongoing support obligation for their children, and the court does take that into consideration, and oftentimes the court will restrict the use of a special needs trust so that the family has to continue to provide basic support, and the court will frown upon a special needs trust supplanting that obligation of the parents. So again, that's something that the trustee really has to make clear to families, particularly at the outset, so that there's not uneasy feelings between the two. Another thing to keep in mind, and I alluded to this a moment ago, is that special needs are really not special. A special need can basically be anything that a beneficiary needs or wants, so long as it doesn't run afoul of the benefit rules, and we'll talk about those in a minute. The distributions from a special needs trust do not need to be directly related to a person's disability. So again, we can provide for general support needs if that's necessary for adult beneficiaries. We can provide for travel, recreation, socialization activities, all sorts of things that may not be disability related. Distributions can also be made for personal items, services, all of the things that we have listed here. And as you can see, it can be very broad. Again, just something to keep in mind that as long as you aren't giving cash to the beneficiary and you're not making distributions that would cause a reduction of benefits, which are primarily food or shelter distributions, then pretty much you're going to satisfy the requirements of the benefit agencies. That's not to say you're going to necessarily satisfy the concerns of the court, but as far as benefits eligibility, you're going to be pretty okay as long as you avoid cash distributions and food and shelter distributions. Okay, another important concept with regards to special needs trusts to keep in mind is that under both SSI rules and Medi-Cal rules, a special needs trust must be drafted so that it provides for the sole benefit of the benefits recipient. What this means is that when you're serving as trustee, you're not permitted to make distributions that benefit third parties, someone other than the primary beneficiary of the trust. This seems simple on its face, but sometimes can get a little complicated and convoluted. Distributions cannot be made directly for another person. That seems fairly obvious. So we can't buy items that are intended for someone other than the beneficiary. We can't make gifts from a special needs trust, nor can we make donations to either charitable organizations or religious organizations. And what's sometimes difficult for our adult beneficiaries is we can't use the funds in the special needs trust to support immediate family members, including the children of the beneficiary. And this can particularly be difficult when we have single parents who suddenly are receiving funds, and they obviously would like to be able to support their children as well as themselves with the trust. And that's just simply that, unfortunately, something that can't be accomplished through these trusts without running afoul of the benefit rules. It's also often difficult for beneficiaries to understand that they can't make gifts to others using the resources of the trust. So, we oftentimes are working with trustees where there might be a request for money to buy a birthday present for a close family member or friend, things of that nature. And unfortunately, again, we just have to say that those are not permissible distributions. However, as I mentioned, sometimes these rules can get a little complicated, and there may be instances where you're considering a distribution or a disbursement from the trust which is going to result in some secondary benefit to people other than the primary beneficiary. And you really have to kind of assess those on a case-by-case basis. I encourage you, if you're working with counsel like the Dale Law Firm or another firm, that you consult with your counsel before making these types of distributions. However, they can in some circumstances be permissible. I've given some examples here on the slide that come up frequently. Travel expenses for an individual to travel with the trust beneficiary is something that comes up a lot. And this may be permissible, and I say may with some emphasis, provided that the individual, the beneficiary individual, could not travel without personal assistance. And in that case, in order for the primary beneficiary to be able to take advantage of travel opportunities, social events and things like that, sometimes it's simply necessary to pay for companion travel. And that is generally acceptable, and the courts are usually fairly accommodating of that, provided that it's reasonable. Usually with a severely disabled person with severe physical disabilities, we can even pay for perhaps 2 traveling companions, because obviously this person may need more than 8 hours, 12 hours a day of support. So again, but I often, or I would certainly encourage people to talk with counsel in these situations to make sure that we're not going to run afoul of your individual court's rules or preferences. Vehicles are another issue that come up a lot in trust distribution requests. It's very, very common for special needs trust, particularly again with individuals with physical disabilities, to purchase adapted vehicles for wheelchair access and things like that. Those vehicles can be quite expensive, and so they're frequently things that the trust will provide for. However, because of trust liability, we don't like to have the vehicle titled in the name of the trust. So it's usually going to be titled in the name of a third person. And there again, you get into this kind of joint benefit. If the person is the owner of the vehicle, presumably they're probably driving the vehicle a little bit for personal benefit as well. And there, what we do to satisfy the court concerns usually is we'll have the vehicle titled in the name of a third-party individual, but the trustee will put a lien through the Department of Motor Vehicles on the vehicle so that it can't be sold without the trust being involved in that process. We also would normally require that the trust be listed as the loss payee on the vehicle insurance, so that if there's an accident and the vehicle is totaled, any payments from the insurance claim are going to go directly back to the trust. And again, with those conditions, the courts are usually quite amenable to authorizing purchases of vehicles. And finally, the other example here is caregiver fees. Excuse me, not caregiver fees, but rent for family members to live in a trust-owned home where they're providing caregiving services. This is a situation where, obviously the family member is getting a secondary benefit to the purchase of the home by the trust, but it's justified in that the disabled individual is receiving care from that family member, and in lieu of compensation, free rent, room and board, that sort of thing is usually permissible. There will be, again, with trust-owned homes, the court may put some conditions on that. For instance, other family members who are not providing direct care may have to pay rent to the trust. There may be restrictions on who's allowed to live in the home, things like that. But generally, it's okay for parents particularly, and possibly other caregiving family members, to reside in the home without paying rent. So those are just some examples of where you've kind of got dual benefit, but they are permitted within the confines of the trust. Along that same vein, there's certain distributions that will require prior court authorization before making the purchase. And this is really a court requirement. The benefit agencies are not going to be concerned with this, but certainly the court, when they're monitoring these trusts, is not going to want to see certain purchases being made without you first getting authorization from the court, and basically the court's blessing. I mentioned a moment ago home purchases and major home improvements. So this is obviously something where, prior to you as trustee spending possibly hundreds of thousands or not millions of dollars in the Bay Area housing market, you would certainly want to get the court's blessing before moving forward with a home purchase. Now, because of the way the court process works, which is not terribly fast for those of you that are familiar with working with our courts, this can pose its own challenges because, as you know, the housing market's quite hot right now and home sales are happening fairly quickly. So normally what we recommend to trustees in this situation is that before letting your beneficiary or their family go out and shop for a home and find that perfect home, you make sure that you already have the court authorization in hand. So going in early, telling the court, look, we'd like to purchase a home for the use of the beneficiary. This is the area we're thinking of buying in. This is the price range we're looking at, and kind of making your case to the court and getting the authorization before you go out and find the actual home. It certainly saves a lot of hurt feelings when the family suddenly isn't told, no, we can't buy you that house this week, that you just set your heart on. So, vehicle purchases, much of the same, obviously not as expensive as buying a home, but again, it's a big ticket item for the court, and the court is going to want to review any vehicle purchases before the purchase is made. Caregiving and personal attendant wages. So here, because this is often a long-term and significant investment that the court is making, or not the court, excuse me, that the trust is making, we usually recommend that caregiving wages also be pre-approved by the court, particularly if the caregiver is going to be a family member. Again, we get back to this tension between when is the family member providing support that they should provide as the parent, because again, normally we're talking about parents here, versus when are they really acting above and beyond their normal parental obligation. So this is something that you always have to keep in mind when addressing the court with family member caregiving. The court is always going to be concerned that we're not paying mom just to be mom. They're going to want you to justify why they should be paid for providing care to their son or daughter. High value purchases, it's always advisable to get court authorization for those, and this could be anything from durable medical equipment, very complex speech devices. We recently had a purchase where we needed a piece of technology for someone's communication purposes that was in the $25,000, $30,000 range. And in that case, we would want to go to court and make sure that the court is okay with that. Generally, those sorts of things are not difficult for the court to approve. They're clearly appropriate, but just because of the size of the purchase, you as the trustee don't want to be on the hook if you go to court after the fact and the court has a problem with it. So it's always good to ask for permission rather than asking for forgiveness. And then last on the list is the unusual and non-traditional purchases. And again, this can range the gamut. I've seen things from in vitro fertilization requests, stem cell treatment, any sort of kind of emergency, or not emergency, but experimental medical treatment. We've had requests for, I think the funniest one, and I probably shouldn't make fun, but somebody wanted us to exorcise their house, or they thought it was haunted and they wanted to have someone come into the home and cure the ghosts or get them out. So all those things are just really outside the norm, and the court is going to look at you a little askance. So again, it's better to ask for permission before you go ahead and spend money on things that the court might think were either inappropriate, frivolous, or just not necessary for the benefit of the beneficiary. And as it says at the end of the slide, if you're unsure of whether or not you should ask the court for permission, ask your attorney. The worst thing you want to do is go out on a limb and make a disbursement for something and then have the court upset with you after you've done that, because the consequences can be dire. I mean, it doesn't happen often, but the court certainly has it within its power to surcharge the trustee back for the cost of that disbursement if they feel that it was improper. So you don't want to be in the position of having to reimburse the trust for something. And so it's better to go into court and get the okay before you move forward. Just so you kind of know when you go to court what's going to be expected by the court when you're making these sorts of disbursement requests. They're going to want a detailed description of the property or the item that you're looking to purchase or service in the case of caregiving. They're going to want an estimate of the cost. And so, for vehicles and houses, that's not so difficult. You can just kind of get estimates and present that to the court as part of your request. If it's caregiving services, you'd want to set an hourly rate, give the court a range of hours that are going to be paid. Sometimes the court will want to set an exact amount, so they might say you're authorized to spend up to, $2,000 a month or something like that. But you want to have an idea of the amount of the request and what it's going to cost. And then in many instances, you're going to need to justify to the court why it's necessary or how it benefits the beneficiary. Again, some of these things are obvious. A wheelchair van is going to be an obvious disbursement for someone that's in a wheelchair. And you're probably not going to have to really sell that to the court too much, other than maybe grappling with the type of vehicle and the actual cost of the vehicle. But the need for the vehicle is going to be somewhat clear. It gets less clear sometimes when we're talking about care, because the court doesn't always have a clear handle on the needs of the beneficiary. So we oftentimes for that will use a care manager's assessment. We'll actually put together an independent report with a narrative from a professional explaining what the care needs of the individual are, and how the care that mom is providing is really above and beyond what is typically being provided by a mother for a child. The nice thing about a care manager's assessment in those cases as well is it can also help you set rates for the level of care that the individual is going to be providing. Is it just basic attendant care? Is it LVN level care? Is it nursing level care? And what would be an appropriate amount for that. Sometimes when we have other types of things like durable medical equipment I mentioned earlier, another that we used to get more frequently than we do now would be requests for installation of swimming pools, particularly where we had a trust-owned home. They might want a therapeutic pool. And in those instances, having something from a doctor or a therapist that really supports the need and the benefit for those is helpful as well. The court is also going to want to know what the financial impact on the trust is. So, how much money do we have available? Can we really afford the distribution that's being requested? And, how is this going to impact the trust long term? If it's a home, are we going to be able to afford to continue to maintain the home? Are we going to be able to pay the annual property taxes and the insurance and all of the other costs that go along with home ownership? All of those things are going to factor in when you're requesting those sorts of things from the court. And then again, obviously, just any other special conditions or circumstances with regards to the purchase, you should lay that all out for the court. This is the section where, for instance, if we're doing a home purchase and we know there's going to be family members living in the home, we would certainly want to advise the court of that and let the court know how we're intending to accommodate other residents in the home, how costs of household expenses are going to be shared, utilities, all of that would need to be addressed in your petition. So as you can see, these are not simple, one paragraph requests. We really do have to provide evidence to the court to let them know how it's going to work and the benefits of the disbursement. The timing of your requests for these sorts of petitions. So a disbursement request to the court can really be brought at any time. And so, if we've got a situation where we know we have to buy a house in the next 6 months, we certainly can bring a standalone petition under the probate code section 17200, and the court would entertain that and rule on it. But there is costs obviously involved every time you go to court. So our preferred practice is to bring these sorts of requests when we know we're going to be doing the periodic accounting petitions to the court, so that way we are not unduly burdening the trust with legal fees. There's also a mechanism for bringing an emergency petition. We can sometimes bring these requests either directly through an ex parte if it's something small, like maybe buying a smaller dollar value item, or even sometimes cars we can bring on an ex parte basis if there's an emergency need for the purchase. Otherwise, we can bring a standard petition, but then ask the court through an ex parte request to shorten the time for hearing that petition and waiving the normal notice period so that that can be heard in a much quicker manner. But again, if at all possible, the best practice is to try and plan ahead, talk with the family or the beneficiary and find out what sorts of disbursements are going to be needed in the future, and then try and bring those petitions when you're bringing the regularly scheduled account petitions, so that we're getting the best bang for our legal fee buck. Okay, I talked a minute ago about the things that you shouldn't spend money on, but there's also mechanisms that you need to keep in mind when administering a trust as to how you need to make disbursements from a special needs trust. The most common method is to pay for things directly. So if you're purchasing furniture at a furniture store, if the trust can pay the furniture store directly, that's usually the best way to make the purchase for a couple of reasons. One is, as noted in the slide here, we want to make sure we're paying not to the beneficiary but to third parties, because otherwise it is considered income to the beneficiary. But also for record keeping purposes, the cleaner the distributions, the better. We don't have to explain convoluted sorts of distributions. So making payment directly to stores, vendors, providers of service, that's really the best way to make disbursements if you can. But sometimes that's simply not practical. So for instance, an example would be if the beneficiary needs some clothes. You know, it's not practical oftentimes for the trustee to go down to the clothing store with the beneficiary with the trust checkbook in hand and write a check to Macy's. I'm not even sure if Macy's takes checks any longer. Do people still use checks when they shop? I'm not sure. But, you know, sometimes it's just not simply practical. So other ways of doing it are to have a third party make a purchase on behalf of the beneficiary, and then you can reimburse the third party. So if beneficiary goes down with sister to Macy's and sister buys, you know, the new winter coat for the beneficiary, the trust can reimburse the sister, and there's no benefit consequence to that. And so long as you can show the transaction cleanly to the court's going to be fine with those sorts of third-party reimbursements as well. And then the other method that is used commonly with our older beneficiaries, clients that have capacity and really can make purchases for themselves were it not for the fact that they're on benefits and they can't receive cash, is we're now using credit cards. And I say we, I mean trustees that we work with are now using credit cards, and or there's a new type of a preloaded debit card called a TrueLink card that's becoming really popular with trustees. And these are mechanisms where a trust beneficiary or perhaps a family member on behalf of the beneficiary can make purchases, you know, take care of the day-to-day expenses that need to be covered. And then the trustee would simply pay the credit card bill at the end of the month, or would reload the preloaded debit card. And that's another way of making the purchases without running afoul of the rules for SSI and Medi-Cal. None of those purchase methods are going to result in the benefit agencies believing that the trust beneficiary has received direct income. So, okay. Now that we've talked about disbursements from the trust, how those are made, I'm going to start talking about the court accounting process itself. So, under the probate code here in California, it's required that a trustee of any court-ordered trust, and that would include settlement trusts and other forms of court-ordered trust, not just special needs trusts, but it's required that they present an account for approval by the court, and this is supposed to be done after the first year of trust administration, and then typically on a 2-year schedule thereafter. Now, the frequency of these accounts can be modified by the court if the court finds good cause. So in some instances, the court will require accounts more frequently. So rather than biannually, sometimes if there's issues, the court might still require an annual accounting. But they can also extend it out longer, again, if there's good cause. So it's not uncommon where if we've got smaller trusts that where the legal fees are really a burden to the trust, the court might extend those out to 3 or 4 or even 5-year account periods. Again, but that's going to be at the discretion of the court. The probate code otherwise is going to default to that first year and then every 2 years thereafter. Also, the court accounting pleadings are going to need to be filed with the court about 90 days after the close of the account period. Now, in some counties, they will actually set a filing deadline for the accounting, so you have a specific date by which you must file the account. And in other counties, they'll have what's called a status hearing, which is an actual court hearing. And if the account is not filed prior to that date, then your counsel or the trustee will have to go into court to actually explain to the judge why the account hasn't been filed yet. That doesn't happen in all counties, but it certainly does happen in a number of them. Okay, a court accounting is going to have three basic components as part of what needs to be submitted to the court. The first is the actual account petition. That's the legal pleading that is usually going to be prepared by your attorney if you're working with one. And that document is going to include basically a narrative description of the activities of the trust during the account period. It's going to provide the court with certain required information that has to be included. And then it also gives you an opportunity, as I said, to incorporate requests for disbursements or any unusual things that you know might be coming up in the future that you either want the court to give its blessing to, authorize, or just to be aware of, because it may have impact on how you're administering the trust. There's also going to be a set of account schedules that are going to need to be prepared, and these are detailed financial statements. There's a set of different statements. They're required under the probate code as to their formatting and what is contained within them. But basically, they're going to itemize and categorize every single transaction on the trust for the account period. That's going to include every bit of income or receipts that have come into the trust, all distributions that have been made out of the trust, as well as changes in assets. If you buy and sell stocks, you're going to have to record all of those transactions in these very detailed financial statements. The court is also going to require that original account statements from the financial institutions be submitted to the court as part of this process as well. For non-professional and corporate trustees, the requirement is that an original financial statement for each account showing the beginning date and the ending date of the account period be submitted. If you happen to be a professional fiduciary licensed in the state of California, then you're required to actually provide all of the account statements for the entire account period. With regards to bank statements, this is actually one of the more challenging aspects of our job, because we find that many trustees don't actually either receive or they don't retain the original bank statements. And oftentimes they don't realize that we need it until we get to the end of the account period and we're asking them for something they don't have. So I'm reminding you all right now, and if you're just watching this video or watching the webinar today as an incoming trustee, know that you need to make sure your bank or financial institution is sending you original statements. Do not sign up for electronic bank statements. Do not let them send you email statements, because those, unfortunately, are not considered originals by the court. The court actually wants those documents that they send you in the mail that are on their fancy little account statement papers. And it's also a good practice to, when you're setting up your bank accounts or your financial accounts, to ask that the financial institution actually send a duplicate copy of the statements to your attorney. That way the attorney has them in the file, and we've got the information we need when the account time rolls around, and it's much more efficient and quicker for us to prepare all of the documentation. Okay, the account schedules themselves, again, I mentioned they're quite detailed, and there's a set or several different statements that are required by the court. I've listed here on the slide the ones that are absolutely required, and you'll see that they include schedules of assets for both the opening and the closing balances of all of the accounts, and that does need to list all of the assets with both their carry and market values. That would include vehicles, that would include real estate, as well as stocks, bonds, accounts, that sort of thing. You're also going to need to include a schedule that shows the value of any assets received during the account period, as well as receipts, and that would be things like income, principal, dividends, interest, all of that. Gains on sales also, so if you're selling securities and you realize a gain, those gains need to be reported on a separate schedule. On the other side of the ledger, where we've got money flowing out of the trust, you're going to need to provide a detailed description of all disbursements made from the trust. And this is going to include the date of the disbursement, who the payee was, the amount, obviously, and then a detailed description as to what it was for if it's not obvious. Then you're going to have a schedule that shows loss on sales, so we balance that against your gains. And then, as I mentioned a minute ago, also the property on hand at the end of the account period. Now, again, these are the schedules that are required. There are other schedules that you might periodically need to include. A change in form of assets is one that we commonly use, again, particularly in trusts where we have a lot of stock or other investment activity, where we're buying and selling and exchanging different assets or investments. We're going to show a lot of those transactions on a change of form of asset schedule. There's sometimes supplemental schedules that might explain other unusual transactions, or if we need to provide more detail on certain transactions, that's sometimes done through a supplemental schedule. Okay, to prepare the account schedules themselves, much of the information that's needed to prepare these schedules, again, is going to be shown on the financial statements from your financial institutions. So again, another reason why it's really important to keep those records and have them available for your attorney or the CPA that you work with to prepare the schedules. It's also necessary for you to have a detailed disbursement log. Because again, I mentioned that one of the schedules you have to provide not only includes the date, the amount, and the payee on disbursements, but we have to explain to the court what the disbursement was. Now, for some things, this is obvious. If you made a disbursement to the Chevron gas station, we pretty much know you bought some gas for a trust-owned vehicle. However, if you spent money at Target, we're not going to know what you purchased at Target, so we're going to need something that really spells that out for us. And it's not sufficient to simply say personal items. We need to actually be able to tell the court what those items were. Was it clothing? Was it personal hygiene items? Was it electronics? Was it, whatever else it is they sell at Target? Toys. Those things all need to be spelled out for the court. And if you've made a variety of purchases at Target, you bought clothes and toys, then we're going to need to break it down further and tell the court how much you spent on each. So again, a detailed distribution or disbursement log is critical. And then I mentioned earlier that another method of making disbursements, which is becoming more popular lately, is for the trustee to authorize someone to use a credit card or a TrueLink card. It's also necessary to provide the court, as part of the accounting, a separate schedule that is going to detail those transactions as well. Because on your trust disbursement schedule, it's just going to simply show that you made a payment to Wells Fargo Bank Visa. We have to be able to tell the court what was on the Visa bill, what did you pay for through use of that credit card. So we find the easiest way to do that is to have a separate supplemental schedule attached that will itemize each of those credit card or TrueLink transactions. So what that means for you as the trustee is really that you're going to need to keep track of that. And if you're working with a beneficiary or a family member, you're going to need to require that they provide you with the receipts for those transactions, or at least a detailed description as to what they're purchasing, so that you can report that back to the court. It's also necessary not just for court purposes, because Social Security or Medi-Cal can also audit these trusts, and if they see that you're making large distributions to a credit card or you're loading a TrueLink account, they too can ask what's being purchased with those cards, and you need to be able to report that to them as well for benefit purposes. On the next slide, I've kind of given you an example of just some how your disbursement log might be set out. And as you can see here, we've got 3 separate transactions that we've kind of made up. And you'll see that we've got the date, the payee, the amount, and then a breakout as to what was actually purchased. Again, some of them are obvious. Jane Doe DDS is a dentist, so we know that's for dental work. But the Target example there, again, is going to illustrate how we need you to break out the individual items, or at least categories of items that you've purchased at those sorts of stores that are a little less obvious. I mentioned a moment ago that for purposes of the credit card and TrueLink disbursements particularly, you're going to want to have receipts and invoices, but that's a good practice for trustees overall. because again, you can be asked at times to provide those receipts if the court, for whatever reason, feels it would be helpful to have them. We had a client recently who had purchased a lot of clothing for a beneficiary, and we actually had the we actually had the court require that we provide them with copies of all of the clothing receipts. So it can occasionally come up where you need to be able to produce those. So it's good practice to ask and to save those. Preparation of the account schedules, as you might have gathered from the description that I just gave you, can be fairly daunting, particularly if you've got a lot of raw data that you're trying to extract the information from. So we really encourage trustees, particularly non-professional trustees, to work with a CPA that's experienced in putting these sorts of account schedules together. If you're a client of the Dale Law Firm and you're working with us, we will actually have you send us the raw data, and then we work with a CPA who does these for us routinely. Because he does them day in and day out, he's very efficient and hopefully less expensive than a less experienced CPA would be. But nonetheless, it can be very difficult to put these schedules together if you're trying to do it on your own. Okay, once the petition is all put together, oh, actually, I'm sorry, I forgot to tell you what has to be in the petition. So the petition's going to be, as I said, usually prepared by counsel. And we're going to start doing that once we've gotten the schedules put together from the CPA. Upon receipt of those schedules, if we're working with you, my paralegal and myself will review those schedules, and we will then ask you for clarification on anything that we don't quite understand. Sometimes there's disbursements that have been made that we need to better explain. So there's oftentimes kind of a series of communications back and forth where we'll ask lots of questions. We're not doing that to be nosy. We're doing it because we have to be able to explain these things to the court, and so we need that extra information. So sometimes I know trustees can get a little annoyed because we ask lots of questions, but we're doing it for a reason. Once we receive that explanation, then we're going to put together the actual legal pleading that's going to get filed with the court with the schedules attached. And that pleading is where we also have an opportunity to explain any unusual activity, any unusual disbursements that have been made for the trust. If there's any unusual activity on the investment side, we can explain that in there as well. It's really kind of the narrative document that tells the court, it gives them the picture of what's been going on with this trust for the last year or two. We're also going to, as I mentioned earlier, incorporate any disbursement requests in that petition. And then within the petition, we also are going to seek approval of trustee and attorney's fees because those do require court approval before they can be paid. And we're going to also review the sufficiency of the bond that the court has required that the trustee post and have the bond adjusted either upwards or downwards depending on the changed value of the trust account. Okay, the account petition, once it's prepared, it's going to get filed with the court, and then it's going to be mailed to all of the interested parties with regards to the trust, and that has to be done at a minimum of 30 days before the hearing date. The interested parties then have an opportunity to appear at the hearing and can address the court with any concerns they may have, or if there's any other information that interested parties want the court to be made aware of, that can all be addressed at the hearing. I will say it's not terribly common for parties to appear. Most often at these hearings, it's usually just me on behalf of the trustee, but certainly we encourage other interested parties to be involved in the court process if they choose to. The account petition similarly is going to be thoroughly reviewed by a member of the court staff. Each county has probate examiners. These are individuals hired by the court that specialize in reviewing all of the probate pleadings and activities, and I can certainly assure you that these court accountings are a big part of what they do day in and day out. And oftentimes what happens is when they do their review, they will reach out to us and ask for additional information. They will usually issue what's called probate notes, and these are basically a form of written communication from the court back to the parties or to counsel saying we've got questions about this or that, or there might be procedural issues that need to be addressed, and that's all set out in the probate notes. We are then given an opportunity to respond to those notes, answer any additional questions that the court may have. This will oftentimes require us to again reach out to the trustee and have some communications and ask questions, and a lot of times the trustee might then have to do some sort of supplemental paperwork. That all gets filed with the court before the hearing. As you might imagine, sometimes that work can cause the hearing to be continued. Sometimes families find that annoying, but it is part of the process, and you do have to kind of be prepared that that's a possibility, that hearings oftentimes will get continued so that the court can complete its review and finish its work. Once that's all done, if the court then finds everything is in order and the court doesn't have any concerns, then quite often the court will issue what's called a pre-grant order or a tentative ruling granting the petition. When that happens, what that means is that we don't actually have to appear at the hearing. The court is telling us that they're willing to approve the petition without an appearance, and they just sign the paperwork on the day of the hearing and it gets mailed to us. That's good because it saves everybody money, because you're not paying the attorney to have to go to court. And it means that the court is approving everything that you, as the trustee, have done for the prior account period. Okay, one other issue that comes up that sometimes takes trustees a bit by surprise is this idea of bond. The probate code in California requires that all trustees of court-ordered trusts secure and file a bond in an amount that's sufficient to protect the assets of the trust. There is a calculation of how we calculate this amount that's set out in the probate code. You can roughly think, and this is roughly, it's going to be the market value of the trust plus 15%. And the way we calculate that is we kind of use 5% generally is about the amount of annual income that we kind of expect in these trusts. Plus the court usually requires 10% for potential recovery costs if the bond needs to be recovered against. So that's where we come up with the calculation. There is a bond premium that is going to have to be paid from the trust to cover that bond. And the bond premium is obviously directly related to the value of the bond. So if you have $1 million premium, $1 million trust, your premium is going to be much higher than if you have a $100,000 trust. It's just the amount of risk that the surety company is putting at stake. The trustee also has to qualify for issuance of the bond. So in order to do that, the bond company who's issuing the bond has to be assured that the trustee is worthy of being bonded, and they look at the individual's credit rating as well as whether they have any personal assets to secure the bond. Because again, the process would be that if the trust were to surcharge against the bond for recovery to the trust, the bond company assuredly is going to go back against the trustee to try and recover that amount. So they want to make sure that there's something for them to recover from. And then trustees also have to realize that there's going to be an annual premium that's going to be paid for the bond, and failure to maintain that and pay that in a timely manner would be brought to the attention of the court, and the court could sanction and or remove the trustee if they fail to keep their bond in place. All right. Trust investments is another area of concern. And the court takes this quite seriously. Again, the benefit agencies don't really care so much how you manage the money as far as investments, but the court certainly does. A trustee in California actually has a fiduciary duty to prudently invest the trust property. It would be a violation or a breach of your fiduciary duty if you allowed the trust assets to sit fallow and not be productive. So the court certainly does expect that you're going to be actively investing the trust assets. And this is particularly the case in larger trusts. I mean, again, you kind of have to think about it practically. If you got a trust with $70,000 in it, the investment opportunities available to you are really not going to be that significant. But if you've got, $1 million trust, the court is absolutely going to expect that you're going to be using that to make some income for the trust and to grow the assets of the trust. So a failure to do that can certainly result in a sanction and or, again, your removal as trustee. Now, we certainly recommend clients that, particularly in larger trust situations, to work with a financial advisor who is familiar with the management of special needs trust assets. And, a lot of times people say, oh, well, why do I need to pay an advisor to help me? I can just stick it in a few mutual funds. Well, the reality is, and we've seen this time and time again over the years that we've been working with these sorts of trusts, by using a financial advisor, you're going to get a better return on the trust investments. And those returns in themselves are going to help offset the fee of paying that advisor to assist you. Secondarily, if you properly structure your investments, you're going to be able to take better advantage of the tax situation and the taxes of these trusts. So you're definitely going to want to make sure that you've got your investments positioned so that you are realizing the right amount of income for your beneficiary and not either getting too little or too much income. Okay, I know the print on this slide is really small, but I did want to give everybody the actual language from the probate code that tells you what your available investment options are. They're kind of hard to read, I'm sure, but I'll just tell you quickly. You're allowed to invest in government bonds so long as the maturity dates are less than 5 years. U.S. Treasury bonds are most of them are pretty available. You can invest in any securities that are listed on a stock or bond exchange in the United States. And this is probably the most common investment method that our trustees use. And ETFs, exchange traded funds, fall within this category and are used extensively by a lot of our trustees. The rest of these are less exciting. We've got some forms of mutual funds and then common trust funds, and that's something that would be used only by corporate trustees that have common funds. Now, while that list looks like it's somewhat limiting, you can ask the court to modify the list. So again, this is something that we would do early in the trust administration process. And some of the common expansions that we will ask the court to approve for trustees are the ability to use more wide-ranging mutual funds and also long-term bond funds. So those bonds that would mature greater than 5 years, we often request. And the courts are usually fairly agreeable to those sorts of expansions. And again, anything else that you feel is reasonable and prudent and that you can justify to the court, we can certainly request through a petition to the court. And like I said, generally, unless you're asking for something, kind of outrageous, the court will generally be pretty amenable to granting your request. Okay, just one slide on taxes. As Steve can tell you, I try to avoid taxes wherever and whenever I can, but I have to address them sometimes, so today's the day. So just really quickly, really what we're talking about today when we say a court-ordered special needs trust is really a form of a first-party special needs trust. I am not aware, I've never seen a third-party trust come under court supervision. So we're really talking about these first-party trusts, and they're treated for tax purposes as a form of a grantor trust. Basically what that means is that the tax liability for the income that's generated by the trust investments is going to pass through the trust to the beneficiary. Now, what you do have to keep in mind is that if your beneficiary is a minor, they're going to be subject to what's called the kiddie tax, and that's going to pretty dramatically affect their tax rates. But if they're over 18 or in some cases 21, then it's going to pass through and they're just basically going to be paying the income on the trust investments at their personal tax rate. And again, because most of our beneficiaries are public benefit recipients, I said that backwards, their incomes generally are going to be pretty low. So their tax rates are similarly on the low end of the tax rate scale. So the trust, we get asked this question a lot in April. What am I supposed to be filing with the IRS as the trustee of my son's special needs trust? Generally, a trustee of this type of trust is going to need to issue a Form 1099 to the beneficiary reporting the income that's been earned by the trust out to the beneficiary. Again, that's how we pass it through to the beneficiary. Technically, a trustee of a grantor trust like this does not need to file a Form 1041, which is a fiduciary tax return. Some trustees will still file this, but it's really just for informational purposes because, again, the tax liability is passing through to the grantor, and therefore there is no tax liability to the trust, so a return is really not necessary. So that's my 30 seconds on taxes. Okay, and then the final thing I wanted to talk about today before I open it up for questions is trustee fees. Now, the courts and the trusts do allow for trustees to be compensated for the time that they take when managing a trust. And I know some of you, particularly some of the folks that I know are out in internet land today, you're professional trustees. I assume you kind of already know how you get paid and the rates at which you get paid. But for those non-professionals that are with us today, the courts that you're working with will usually have some method by which they like to pay non-professional trustees. So you should talk with your attorney about kind of what the practice in your county is. But most courts, from my experience, are going to pay a non-professional trustee on an hourly fee rate basis. And I've given you the example here. Contra Costa County, which is the county that I'm sitting in today where we practice a lot, their typical guideline for a non-professional trustee is $40 per hour. The fees must be approved by the court, and you can't pay yourself, except under some limited circumstances where the court has okayed it. You cannot pay yourself your fee without first getting approval for your fee from the court. So we usually bring these fee requests as part of the account petition, and you're going to have to justify the time that you've worked and the rate that you're seeking, and then the court will review it to see that it's reasonable, and typically will grant it without too much hassle. When you're presenting the request to the court is going to expect that you're providing them with a detailed time record that itemizes each of the tasks that you've performed in your role as trustee. It's good practice to formulate those like attorneys do, where we bill in 6-minute increments or tenths of an hour. That's kind of what the court is used to seeing, and they're going to be very familiar with those sorts of billing numbers. So I've kind of given you some examples here of how you could kind of set out your itemization of your time. And again, you're going to want to include the date that the task is performed, what you actually did on behalf of the trust, the amount of time that it took you to perform the task, again in 6-minute increments, and then based on $40 an hour for my example here, I've calculated the time or the amount that you would be paid for your time. And as you can see, the court is going to expect you to be somewhat detailed so that they can actually reasonably review what it is that you've been performing. So reviewing and paying bills, meeting with your financial advisor, reconciling the checking account. Those are the sorts of descriptions that you're going to want to include. Anything too general where the court can't really ascertain what it is you did and whether the time that you're charging for it is reasonable isn't going to be acceptable to the court. So that brings me to the conclusion of the formal presentation. I don't know if we've got any questions from those of you that are here in the room with us, or if anyone online has got some questions, but I'd be happy to answer.
Jennifer, nice to see you.
Good to see you too.
Any examples of recent examples from various courts in the Bay Area where a request was denied, or whether it was to buy a home or for a certain expense?
Right.
Just kind of by way of keeping us all on guard as what you're seeing,
sure,
given all the work that you do.
Sure. I'll be honest, it's not too common that we see requests denied outright. What's more common is to have the court pare down a request. So you mentioned a home purchase, for instance. I had a case a while back in the Sacramento area where a beneficiary wanted to buy a home in Rancho Cordova. I'm not familiar with real estate in the greater Sacramento area. They were requesting a certain amount for a house in that neighborhood, and the judge looked at it and he said, well, I'm somewhat familiar with the real estate in that area, and a house shouldn't cost that much, and I don't know why you want that much. And he ended up paring it down significantly. I think the request might have been $700 and we got like $450. So those sorts of reductions will happen sometimes if the court thinks that something is excessive. Similarly, vehicle requests sometimes, courts don't like luxury vehicles. So if you're looking for a wheelchair van, for instance, the Mercedes Sprinter is probably not your best choice. Go with the Honda Odyssey. Those sorts of just perception issues sometimes come up with the court. Now, of course, if you have a real good reason why the Mercedes Sprinter is necessary, and I've actually had this where because you can stand up in the Mercedes Sprinter, maybe that's necessary for your particular beneficiary, that might fly. But generally, those sorts of kind of perception issues. Why do we need the Mercedes when we could get the Honda? Those you'll get those sorts of pushback from the courts as well. The only other time I've ever had anything rejected outright is usually because the request is putting too big of a financial load on the trust, and that sometimes again can come up with homes where if you've got a fairly modest trust and you're asking to use like 80% of the trust principal to buy real estate, the court's probably going to say no to that request, because then their concern is you don't have a lot of cash left to maintain this house over the long term. We don't want the house to fall into foreclosure, those sorts of concerns. But usually they're pretty good about, the judges are pretty good about working with you to figure out a solution that satisfies them as well as the beneficiary.
Okay, and then you had mentioned something about that in some cases you can appear ex parte. What is an ex parte?
Oh, yeah. I like to throw around legal lingo that nobody else knows. So ex parte simply is a process where you can make a request to the court where the court waives the normal notice period to all of the interested parties. So as I mentioned, I think in my presentation, typically when we're making these sorts of petitions to the court, we have to give 30 days notice to all of the interested parties so that everyone has an adequate amount of time to review the petition and determine whether they agree or disagree, and they can file an objection if they don't like it. An ex parte proceeding is where the court basically waives that and allows you to go in, usually on 48 hours notice. And usually that notice is a verbal notice where we would let everyone know we're going to be going in next Tuesday and making this request, and if you have an objection, let us know.
Okay. And then another question that I know comes up is, for those that are fee sensitive, which I think is everybody here, what are some things that people could do to try to keep their fees down?
Keep really, really good records. If anything drives the fees in these cases up, it's bad record keeping. If I or my staff have to continually be going back to the trustee and asking for more information or corrected information, or we need something to justify this or that expense, then each of those phone calls, each of those emails costs attorney's fees, and that's really the one thing that we see escalate the cost of these proceedings pretty substantially. Otherwise, there's just a certain amount of cost, unfortunately, in administering these trusts that's unavoidable. We get a lot of clients want to know, well, how come I have to have this bond and pay this big bond premium? The reality is, unfortunately, it's just a legal requirement. There's nothing we can do about it. It's required in every case. So you just have to accept that there is some costs involved in administering these types of trusts.
And then the other thing with the bond is, do you really have to have bond, and is there a way around it?
The only way to avoid bond in these cases is to have a corporate trustee. Corporate trustees are not required to have a bond. However, the fees that you're going to pay to a corporate trustee are probably going to, in many times over, surpass the premium for the bond. So, having a corporate trustee in a larger case sometimes makes some sense. And I'm not saying that I don't favor them in certain cases, but certainly, particularly in the smaller value cases, they're not even an option. And, the costs for the bond are going to certainly be less than what you're going to pay in fiduciary fees to a corporate.
Okay, and then do clients have to be represented by counsel? Can they do this on their own?
Unfortunately, they do have to be represented by counsel. Because it's a court requirement. The court would be perfectly happy to let people go pro per, which means they're not represented by an attorney. However, it's a condition of the bond again. The bond company is going to want to make sure that there's an attorney involved, and they do make it a requirement of your bond that you have legal representation.
Great. Well, I certainly learned a lot. I always do. One thing that we might just end on is that, when you're looking at whether you're going to serve as trustee or use a professional trustee or that sort of thing, what kind of things might you think about?
Well, hopefully you've gotten a flavor from the presentation today as to the kind of complexities that are involved in managing these trusts. And again, balancing both the benefit rules with the court's requirements can be quite daunting for family members, particularly if they're not used to managing these sorts of assets. A lot of times the family members of our beneficiaries spend a lot of time providing personal care and other supports for the disabled family member, and adding this burden to, you know, the already overwhelming tasks that a family is facing. It's just simply not worth it for the extra stress. But then there are family members that do a bang up job and do, you know, that this was really their forte. So, you know, there's no cookie cutter answer. I think for some families, managing the trust yourself is fine, and for others, it's a recipe for disaster. But you kind of have to just go with it and see how it works out. And we can always change the model down the road. You do have to go to court to have the trustee changed, but you know, it's not uncommon for a family trustee to find out after a year or so that they've bitten off more than they can chew, and then we'll go in and change the model. So
I also think it's fair to say that in a lot of cases, these accountings aren't like any other accounting most folks have ever seen here. In fact, for the typical CPA, I know I can really throw them, because a lot of what these accountings are all about aren't what the CPAs are used to. So I think that, you know, one possibility about this, if you're a family member, is you might want to, you know, make sure that we know that you might want to be trustee, but maybe consider using a professional trustee for one or two accountings. And then if you really think you can do this at that point, you can always change it, usually at one of the accountings.
Right.
Right.
Yeah, as time goes on and you see how it works, we can always do the reverse. We can have the professional replaced with a family member as well.
But, you know, the fact is that for a lot of professional trustees, they're used to these accountings. And I think it's fair to say that in most cases, we're going to see the accounting costs will go down if we have somebody who's really on top of it.
Yeah, and I think that's the thing. A lot of times families initially think they're going to save money by not having a professional, because they don't want to have to pay the professional the compensation involved. But again, you're right. Sometimes what transpires is that the legal fees then go up, because the professional is going to manage things with us much more efficiently. And in addition, our professionally managed trusts typically perform better on the investment side as well. So it usually ends up being kind of a wash, to be honest.
Okay, well, I think that, you know, learned a lot. Hopefully this is a good primer on court accountings. And I know the other thing that you had in there is, if there's something you're not sure about, ask.
Absolutely. Whenever you're not sure, call, email.
Okay.
Whatever.
Email, call,
Right.
Whatever. So anyway, I want to thank you for those of you that are watching either live or on YouTube or watching later. Please consider subscribing to our channel. We have all sorts of programs that we're doing on all sorts of different subjects here. So we'll continue to build our library. And with that, I want to thank you very much for the presentation. And for those of you watching, happy advocating.
Yeah, absolutely.
Okay.
Bye.